Social media is on trial in the state of California, the first of a series of trials that may shape the obligations that social media companies have going forward. May it please the audience, I'm Rich Schoenstein, and this is So Sue Me, the podcast about civil litigation, and we have a barn burner out in the state of California. There is a trial ongoing against Meta and YouTube, this platform, and others. Yesterday, Mark Zuckerberg, the founder and head of Facebook and Meta, testified, and it is all about whether or not social media sites are harming kids. That's sort of the short version of it. So yesterday, Mark Zuckerberg testified in the Los Angeles trial about claims that social media makes kids addicted. Unfortunately, this isn't one of those trials that's aired on television. There are no cameras in the courts, and you kind of have to rely on the reporting coming out of it. But we heard a lot about Mark Zuckerberg's testimony. I'll get to that in a minute. But to start, I want to back up. There are apparently some 1,600 different claims and cases pending against social media companies, including Meta, YouTube, TikTok, Snap, in the state of California. This trial is the first of what could potentially be many trials. It's being viewed somewhat as a bellwether, which means a test of whether or not a trial like this, claims like this, can succeed in front of a jury. The claim essentially is a product liability claim, that the product that was being offered, social media product, was designed to addict children, meaning to make them watch more and more and more, and that addiction and the images and content they were shown caused them harm. The particular plaintiff in this trial, we only know the initials, KGM. She's now 20 years old, but at the time was a youngster, and claims that she became addicted to social media sites as a child, which led to anxiety, depression, and body image issues. And you can imagine a claim like that because a lot of people have had that kind of experience where they get drawn into social media and can't get off of it. And the question being posed at this trial is that the fault of the social media company, and can they be held legally responsible? Plaintiff's lawyer in this particular case is Mark Lanier. He is a very well-known, very well-regarded lawyer out of Texas who is famous for these kind of personal injury and product liability claims, including the talc claims against Johnson & Johnson, Vioxx, and many other big tickets. He's won lots of cases. He's settled way more and made a ton of money in this arena. He is a very good, very skilled trial lawyer. And yesterday, the report is that he cross-examined Mark Zuckerberg about Zuckerberg's knowledge and Meta's knowledge that its sites were potentially addictive and potentially caused harm. I would have loved to watch that cross-examination. Actually, I think Lanier put on Zuckerberg as part of his affirmative case. He still gets to cross-examine him, but he called him as a witness, and then after that, Zuckerberg was examined by the lawyers for Meta and asked questions to try to recover. From the reports that I've read, Zuckerberg did okay. He was clearly well prepared. He kept saying that things that were being used against him were taken out of context or were cherry-picked. They kept showing him, things that had been sent around internally at Meta about how to engage more viewers in these sites. The argument being that it was designed to Instagram, for example, was designed to keep people on the site viewing more and more and more, and that was part of the strategy. Zuckerberg said that's not really the strategy anymore. The strategy is more long-term. It doesn't help the sites just to keep people on hours and hours and hours a day because they want lifetime viewers, not viewers who watch 20 hours in a day, and that sort of makes sense. He also highlighted that over the years, there have been innovations at these sites designed to protect children. There's been more effort put into finding out if there are underage users of these websites, because if you're under 13, you're not supposed to be on. There have been sites designed for young users specifically that have more safeguards. Things like that have happened over time. Zuckerberg talked about having had a conversation with Tim Cook at Apple about how they could better protect youth on their sites, and perhaps that happened. One of the questions here is, what were the conditions at the time KGM was on these sites? They perhaps didn't have all of these safeguards, may have been a more harmful environment, and her claims may be valid even if they took corrective action afterwards. In fact, sometimes plaintiffs' lawyers like to argue that the corrective action is itself proof that there was a problem to begin with. What does the plaintiff have to prove in a case like this? Well, I'm going to break it down into really simple terms. Fundamentally, the plaintiff would have to prove that the defendants knew there was a danger or should have known there was a danger and failed to act. They're going to have to prove to some extent that the sites were in fact addictive. And that's going to require a lot of expert testimony and specific testimony about the user. They're going to have to prove that this particular plaintiff did become addicted and that that addiction led to harm. So she's alleging anxiety, depression, body image. They're going to have to prove that those things were caused by the use of the website. And I'm sure the defendants are going to argue it's vice versa. It's not that she went on social media sites and became addicted. It's that she had addictive traits and therefore overused the social media sites. And that kind of thing is going to be the subject of competing expert testimony. But assuming that the plaintiff can prove that the defendants knew or should have known that there was a danger, that that danger led to addiction, and that addiction led to harm, there could be a successful claim and liability could be established, and the jury could assess damages. I don't know offhand if there's a punitive damages component in this case, but once you get into that stage, obviously, the sky's the limit in terms of the kind of damages that a jury could award. Or also, we've seen sometimes juries not award that much. We've seen juries find liability, but in way of compromise, award very little in damages. And that happens in civil cases sometimes, where the jury doesn't quite agree on what the outcome should be. They might compromise on liability, but not much in the way of damages. Interestingly, two of the defendants, TikTok and Snap, settled before the beginning of this trial, staying out of it completely. They must have a strategy for dealing with these cases, a global strategy and not just a case-by-case strategy, because I understand there are something like 1,600 cases waiting in the queue, and that there's litigation in other states. There's a case pending in New Mexico. There are cases in other states. This is being compared to the wave of tobacco litigation some years ago that really changed the way that we view cigarettes and that tobacco companies could do certain things in the country. And it is a big, important case. Sometimes civil litigation is just about determining the outcome of a business dispute between two people or an employment dispute. Sometimes it's just about an injury to one particular person and assessing whether there's liability on the part of somebody else and whether there should be damages. But sometimes litigation is about a big societal question, and that is a purpose of the law and of this area of the law to set societal norms. I talked about those tobacco cases that kind of changed the rules of the road and instituted new ideas about the responsibility of tobacco companies. This could be that kind of thing. The law is a useful tool here in identifying what it is people and companies are supposed to do. What are the limits? How should you act if you have a social media website and you know there are children on there using it? What efforts do you have to make to protect those? What do you do if you know that your product, whether it's social media or something else, is potentially harmful to the users? What actions does a reasonable company have to take in order to protect them? Those are questions that are going to be answered in these trials. And another thing about this kind of litigation is every case is a little bit different, right? So if this plaintiff is successful and establishes liability on behalf of Meta and YouTube, that could set a precedent for future trials. It could be what we call collateral estoppel of certain issues that would hold them liable in other trials against other plaintiffs for having product liability. On the other hand, if the plaintiff loses, it doesn't have that same kind of preclusive effect. That's just one jury ruling against one plaintiff, and other plaintiffs could have a shot. But the reason we look at this as a bellwether litigation is all of the lawyers involved want to understand whether or not these claims are going to be successful. So sometimes when you have a situation where there are hundreds of pending claims in court that are essentially the same, but have to be tried on an individual basis and not on a class basis, you have some trials as bellwethers or tests. You see how they go, and then the parties in the other cases can make educated decisions about how to settle them. So if this plaintiff is successful, the social media companies are going to have to open their pocketbooks and try to settle some of these other cases before they take steep financial hits. On the other hand, if the social media companies can prevail, then the plaintiffs are going to have to think harder about whether they really pursue their case to trial and what they might take to settle. That's why it's really interesting to keep an eye on this. I really wish it was televised. It's a shame not to have cameras in the courtroom. We have cameras in the courtroom for every dopey case involving a celebrity. We have to watch Gwyneth Paltrow's ski case on television, but we can't get a camera in a courtroom for one of the most significant cases about social media that's been in the courtroom yet. I mean, that's ridiculous. You should be able to watch the thing on YouTube, let alone what you think about YouTube. These social media companies face lots and lots of litigation. There are antitrust cases pending. There's other kinds of cases against them. They do a brisk business in litigation and keep a lot of lawyers working very hard. We thank them for that. Now, the test cases are very much about teens and tweens, as this article says, and about children. I think it's obvious that there are claims that social media is designed to be addictive or habit forming for people of all ages, but of course, we're much more concerned about the impact on children than they would be at grown-ups. And if you had a bunch of these cases and were thinking about a bellwether case, you would want to bring to trial first a very strong case, a very likable plaintiff who the jury is going to want to defend. We don't know more about KGM. We haven't seen her. We won't get to see her in a courtroom, but I am presuming that this is an likable plaintiff that they thought would be successful at trial. All right, I'm going to keep my eye on this one. I understand there's 4 more weeks of testimony anticipated before this thing goes to a jury. Remember, as always, cases can settle in the middle of trial. They can settle when the jury goes out. They can settle at any time. So that is still a possibility depending on how the trial goes. I think this case is going to very much depend on the expert testimony about what was addictive and who would have known what was addictive and how that affected this particular plaintiff. I assume that's all going to be forthcoming. The Zuckerberg part is interesting, and I would think was a big moment in the courtroom to try to put some responsibility on the very top, the very face of social media. Whether or not that was successful, I don't know, but there's a lot of ground to go. There's 4 more weeks of trial, the first of many cases. Again, this is a really significant area for civil litigation. This is an area where civil litigation can set societal norms and help frame societal conduct for years to come. It's much more than just a dispute against a couple of parties. So we're definitely going to keep an eye on it right here on So Sue Me. Do not forget to like this video, and if you haven't subscribed, please do so. I guess I don't really care about the numbers, but somebody does. So go ahead and follow us if you can. We appreciate you watching. We'll see you soon. For now, we are adjourned.